Welcome back. Former Northwest Deputy Director of Public Prosecutions, Advocate Sello Maema, has continued his testimony at the Nkabinde Inquiry. Evidence leaders have focused on the lawfulness of the coordination involving South Gauteng NPA boss, Advocate Chauke, questioning his role as provided by then NDPP, Advocate Bhamjee. Maema was entrusted with leading a team of prosecutors who were sent to KZN to look into the Cato Manor killings. He's the first witness brought by the suspended Chauke. Let's reflect on the proceedings with Dr. Suhayfa Bhamjee from the University of KwaZulu-Natal. Good to have you on the program this evening, Dr. Bhamjee. So firstly, the Nkabinde Inquiry, led by retired Justice Nkabinde, is examining serious allegations around the Cato Manor unit. How critical is this for accountability, really, within the NPA?
Thanks, Sello. Thanks for having me back. Yeah, no, so it's, it's really unraveling on very many aspects. We must remember that the Nkabinde Inquiry started out into looking at the fitness of office and the fitness of practice for Advocate Chauke. And where we've ended up is it's unraveled so many other things. We're looking at reopening, possibly re-looking at the Cato Manor unit, things that we were told were put to bed procedurally. We're probably also looking at, depending on how the rest of the testimony plays out and pans out, what this means, whether Chauke is going to be vindicated, whether there's going to be more charges, perhaps, disciplinary inquiries related to him, but also what that might mean for Shamila Batoy, what's her disciplinary. And why I'm getting to this point is because of what Advocate Maema has been saying and has been coming about in his testimony and through the cross-examination.
Dr. Bhamjee, when allegations move from excessive force to claims of a killing squad, what must prosecutors then prove?
Killing squad will go in hand with what we think about racketeering, really, and what we're thinking about in the frame of organized crime. It's, if you're a squad, you're a team, and which means some sort of organization, some sort of plan, some sort of agenda, if you will. And so we're moving just from killings to organized crime. And now we're looking at it from the framework of politically influenced organized crime and interference. So you're looking at a really, really messy bag of tricks here.
Yeah, but how damaging is the alleged lack of authorization and a paper trail?
Look, it definitely can be damaging, but we've got to consider whether in the way in which the Cato Manor unit operated, right? Clearly they were pretty much looking like they were a law unto themselves. Regardless of what orders were given, they had their own agenda going on. So what we're wondering there is now, how is that going to play out? When it comes for Chauke, on the other hand, did he do the right thing in the wrong way? Or, did he do the right thing or did he do the wrong thing? So we're not quite sure where that's going to go. What it is going to be the turning point is, well, if Advocate Baloy, if Shamila Batoy, gets back onto the stand, because we've been told that she has secured legal counsel. If she does come back to complete her testimony and endure cross-examination. The other thing, what is Chauke going to say when he gets his turn in the hot seat? And how is that all going to link up? So we're in for quite a ride.
Yeah. As we continue tracking these hearings, if forensic evidence then contradicts sworn police statements like what we're hearing, how decisive is that legally?
Look, it can be. It can certainly have, what we might say, whether we're drawing adverse inferences or negative inferences in that respect. But again, it's how all of the other pieces of testimony come together and what in that respect the commission is going to say, well, this was credible, this was reliable, this was just not going anywhere, wrapping themselves up in words and, should be dismissed. So it is about what can be backed up, either through corroboration with other witnesses, but again, it depends on how those other witnesses come up as far as credibility is concerned. But if they're backing up one version of events or Chauke's version of events, and then what the other side is going to be able to say to poke holes in that from either way. But it's anybody's game at the moment. It really turns up on who the next witnesses are for Chauke, certainly what he's going to say, and whether Shamila Batoy is actually going to get back in the hot seat.
Yeah, you did mention that the inquiry is also assessing the fitness of DPP Andrew Chauke, but what standards apply there?
Yeah, so the fit and proper test essentially is what it is. And there's much a difference between misconduct and then completely being absolutely unfit and proper. Unfit and proper would be being politically motivated, for example, in the decisions taken, if there were decisions to prosecute or not to prosecute, right? But misconduct means maybe procedurally missing something or and that can be remedied. So when we talk about fit and proper, you're looking at a character flaw that cannot be fixed, but misconduct can be remedied through other means. So that's really the line of whether he is merely responsible or having misconduct, right? Professional misconduct, or is he just simply not fit and proper to carry on? Should he not be an advocate, essentially? That's the question.
Dr. Bhamjee, let's explore another layer. Does the earlier collapse of the case against Johan Boyson, for instance, does it complicate matters now?
Well, I don't know if it complicates the matters for the Chauke and the Nkabinde Inquiry particularly, but what it is doing is, as the testimony is coming out, it's kind of unraveling why it collapsed in that sense. When we listen to Advocate Maema's testimony, he seems to suggest that collapse, the Boyson matter sort of being put to bed or shelved or disappeared, if you will, happened when Shamila Batoy was the director of public prosecutions, before she had even left to go and join the ICJ or the ICC, right? And so he says in his version of events, and Maema's version of events, that she'd already put into place the mechanisms for making the Boyson matter sort of disappear and there be no sort of criminal repercussions or other coming from that. So he's laid that very, very heavy basis for it. And I think what we're seeing is possibly that these investigations and even maybe a case revived in relation to Boyson.
Yeah, but where's the constitutional line, Dr. Bhamjee, between tough policing and the right to life?
Look, that's where we have to also, not just the constitutional, certainly, and also in conjunction with the Criminal Procedure Act, because this debate about use of force, use of deadly force by the police has been in debate for very many times. I mean, looking at Section 49 of the Criminal Procedure Act, and there are firm rules. Use of force, use of deadly force must be the last resort. And it must also only be used when there's really this life and death threat to your own life as the officer, threat to other people in the community. But what's turning out is that this Cato Manor unit were shoot first, think second, or shoot first, investigate second, which does not justify how force should be used. Force in any means, way, and form must be the last resort, and it should be the least amount of force necessary to achieve the end. Because if we ask what is the point of trying to effect an arrest, it's to bring the accused or the suspected person to court to answer, to give. But if the person is shot dead, that can never happen.
Dr. Suhayfa Bhamjee, thank you so much for helping us unpack the legal and constitutional weight of the Nkabinde Inquiry, of course, as we've been tracking developments at these hearings as well. Moving to this.